Okay, good afternoon and a very warm welcome to this innovation workshop, part of the Genesis 2021 conference. I'm Alicia Gallier, Business Development Manager at One Nucleus, and I'm delighted to be welcoming you to this afternoon's session. So I'm joined by Barbara Fleck, partner at Appleyard Lees, and Barbara is going to be our host for this afternoon's workshop. So Barbara is going to be talking to us about getting investment ready from an IP due diligence perspective. We've done these workshops together in the past, haven't we, Barbara? And we like them to be as interactive as possible. So don't be shy. For those who joined this morning, you'll know that the chat box is enabled. So please feel free to drop questions and comments into there. And actually, we found people were raising their hands this morning as well. So that works equally well. I'll be the eyes and I'll keep a lookout for any questions or any raised hands, and I'll pass those to Barbara throughout the session. We are recording, as you've heard, so the session will be featured as part of the on-demand content for the conference as well. And also just to kindly remind, if you're not speaking, then please remain muted. So I'll hand to our host now, Barbara, to take us through to this exciting session. Thank you very much, and over to you, Barbara.
Thank you very much, Alicia, for this kind introduction. And please, if there are any questions in the chat box, I may not be able to see them whilst I'm presenting and focusing on my slides. At any point, please feel free to interrupt me and just say, oh, question has come in. That's absolutely fine. If the audience feel happy with actually unmuting themselves and asking me a question, and again, please feel free to interrupt me. As was just said, we really want to make this an interactive session. We're quite a small group, so I'm really happy to take your questions. I'm going to share my screen now, and bear with me. So apologies for the not full screen format. I'm aware there's a full screen bottom, but trust me, it's not playing ball here with my setup at the moment. So I'm hoping that you'll be able to nevertheless see the slides well enough in this viewing mode. So today we'll be talking about getting investment or deal ready. So how do you prepare for IP due diligence? That's our topic today. And I work a lot with clients that are startup or small companies. So I have a lot of experience in advising clients who are undergoing a due diligence exercise, for example, in seed funding, Series A, B, or C. But I've also been on the other side. So in other words, I have worked for larger companies or investors who have had an interest in investing in smaller companies, and they really wanted to understand what is the IP position of that small company. Is it solid? What are the potential issues that we need to be aware of? So I have seen this exercise being conducted from both sides. I've advised clients on how to best prepare for due diligence. I've talked to the other sides to explain how the IP portfolio, what it is in the IP portfolio, what the scope of the claims is, how we have FTO, etc. But I've also been the one asking the questions that the smaller companies or the other side actually had to answer. So I'm hoping to really give you some real life examples of what kind of questions are being asked. My real life examples, I mean, I won't be going, of course, into client details, but what I mean is that the types of questions that I'm going to show you, or the topics, are really the sort of things that I see all the time. And these are questions that do come up in IP diligence. So we will be looking at those questions, and then we'll be looking at, well, how do you address these questions? What can you do to prepare and be efficient in the process? Because very often these exercises are very, very time critical. So of course we know that IP due diligence is typically required at different stages of a company, but I thought it would be worthwhile just reminding everyone that this is the case. So we have, for example, a spin-out company that is created. So it's an early stage, companies being spun out. The company might be looking for seed investment, or we are looking for larger investment rounds further down the line. It could be an initial public offering. There could be an acquisition of the company, or there could be a licensing deal, for example, to a particular asset of the company. In all of these, and each and every situation, it is very likely that a due diligence exercise will be carried out. So the questions that are being asked during due diligence by the other side are typically, these three questions fall into three different categories. So it's about the IP strategy and the IP portfolio. So how are the company's IP assets protected? The second set of questions relates to ownership. Who owns the IP assets? Are they actually owned by the company? If not, does the company have any rights to these assets, for example, by having in-licensed certain methods or products? And then the third bucket is about freedom to operate. So are there any third-party rights that could present an obstacle to the company's business plan or product launch? So I'll try to pause after each of these sections to invite questions, which I won't see in the chat box. So Alicia, if you could read them out to me, that'd be great. But as I said before, if there's anything you would like to ask me throughout, please feel free to do so. So the first set of questions that often comes up is about IP strategy and the IP portfolio. Just as a reminder, I'll be mostly talking about patents, but of course there are different intellectual property rights. I'm not going to go into trademarks, copyright, design, and trade secrets, but we do need to understand that in an IP due diligence exercise, depending on your company's IP portfolio, these are areas that may also be explored. In particular, know-how and trade secrets, which can be quite critical to a company's intellectual property. But let's focus on patents in this talk. So really the question that will be asked is, what is your IP portfolio? What are the company's IP assets? And the answer to this is initially, of course, providing the other side with a list of these assets. Now, if you are a company that has been in existence for some time, then you have probably amassed a few filings in several jurisdictions. So it could be a fairly extensive list. If you're at an early stage in your company's life cycle, then you probably have only a couple of families that you might have filed for and you need to share with the other side. But you also need to bear in mind if there's any in-licensed technologies. So you may have in-licensed certain IP to enable you to carry out methods, for example, to practice your invention, to work your business plan. So this sort of information should also go to the other side, at least in a listing of IP assets. There will also be questions about the scope and strength of the portfolio. So really what I want to say here is all about the preparation. In my experience over the last 20 years, what investors want to know, what the other side wants to know, whether that's investors or a potential acquirer or licensee, they really want to know, have you done your homework? I think this is really what it boils down to. And you got to be prepared for these questions. You have to be prepared to explain the scope of any granted or pending claims in your portfolio. Be prepared to explain the strengths of your granted or pending claims. So in other words, are there potentially some avenues that other parties might attack these claims? Are you aware that there's perhaps an examiner who hasn't done the examination as thoroughly as he or she might have done, and claims granted that are perhaps not as strong as they seem. You will be asked these questions, and you have to prepare for these questions, as well as explaining your IP strategy. So what are your assets? How are you planning to protect them? How are you branching out your portfolio? How are you ring fencing your invention? And it's, I think, really important to be prepared for these questions so that there isn't a rush when these questions come in. And as I said, these exercises are often very time critical. And if you haven't had a chance to really sit down and think about these questions, it is often very difficult to do that when the due diligence has already started. And especially when you're a small company, there are so many other questions that are probably part of the due diligence, not just IP. So you'll be talking about the science, you'll be talking about the finances, you won't just be talking about IP. IP forms a part of a typical due diligence, but it's not the only part. So really it's about being prepared and having those discussions well in advance. If you're working with a patent attorney, which I'm sure you will be, then have those conversations with your advisor so that you are actually prepared when these questions come in. And I've actually just done the practical tips here, which I've summarized on this slide here. So that's really to emphasize the work that can be done in advance to prepare for these questions about your portfolio. Before I come on to ownership, I just wanted to give you an opportunity to put in any questions in the chat, or if you like, unmute your mic and ask if there's anything you'd like to know about this part of the IP due diligence. This is where the other side will be looking at your IP portfolio, your filings, your in-license technology. We'll be asking questions about your IP strategy. We'll be moving on to ownership and FTO in the next sections. But are there any questions on this section?
There's nothing in the chat as yet, Barbara, just to let you know. And
Okay.
If anybody would rather raise the hand, if that's easy, then I can also see when you do that. So no problem to do that as well.
Right. Okay, so let's move on to ownership. This is the second bucket, if you like, and I find that the questions on IP due diligence, just for the benefit of others who might have dialed in late, typically fall into three buckets. The first one is on the IP portfolio and IP strategy. The second bucket really is about ownership, and the third bucket is about freedom to operate, which means, are there any third-party rights that the other side perhaps needs to be aware of, that need to be flagged? So for the ownership questions, it really is about who owns the IP assets. So there will be questions along the lines of, is all IP recorded in the name of the company? So for example, if there is some IP, perhaps that was initially filed by a university, and then a company is spun out on the back of that IP, then of course the IP eventually will be transferred to that company. And you need to make sure that you have also updated the records with the various patent offices to list the correct applicant. That's an example. There are, of course, others, but really it's about, is the IP in the name of the company? And there will be questions often from US entities when they do due diligence, because US law is different to UK law in many aspects relating to patents. But I often find that they ask questions about the inventors listed. And how does the company own the rights from the inventors? We'll come to that in an example that I'm going to talk about in a minute. And also questions will be asked about, is there IP that is essential to the business operations, which is actually owned by another company? And if so, is there a license in place? I mentioned in the previous section that it's important to list in-license technology also in the in the listing that you provide the other side with. So when we look at inventorship, then as you probably all know, the inventor is the patent application. Ownership stems from inventorship. So the first step is always determining an inventor. Who is the inventor? And what does that actually mean? How is this analysis conducted? I don't want to spend too much time on it, but this is actually quite complicated, and it's not the same as authorship on a scientific paper. Now, in a nutshell, at least under UK law, I like to paraphrase it just by saying that the inventor is the person who comes up with the clever thing, essentially. And routine experimentation is not inventive. Of course, there can be more than one inventor. So you very often find multiple inventors on patent applications. Once the inventor is determined, we can look at ownership. Under UK law, if an invention is made by an employee of a company, and that invention is made in the course of the usual duties of the employee in the course of employment, then the invention belongs to the employer by law. So that's enshrined in legislation. So there is not really any wiggle room. And it's quite clear that if there's a scientist working on developing pharmaceutical compounds for a company, then he or she does so in the course of their employment, and an invention made will belong to the employer under UK law. I found this sometimes a little tricky to explain to US colleagues, because that's not necessarily how US law works. But it's certainly the case that under UK law, there's no separate assignment from the employees required, because by law, the rights to the invention belong to their employer. But of course, things are not all straightforward, are they? We often work with other people. Companies will work with universities, with other collaborators, with consultants. So ownership may be much more complicated than just resting with the companies, because all the inventors are company employees. And in the real world, it's often much more complicated. So, if we just look at a very simple example, if you have a company that's working with a university on developing, say, an antibody, and that may be just an informal collaboration, there's no legal agreement in place. And if you have a person, let's call him John, he works at the company, he develops the lead antibody. And then there's Maria at the university. She actually optimizes the antibody sequence. And this in fact leads to a very surprising improvement in the affinity, which takes everyone by surprise, couldn't have been predicted. She does something very clever, slightly unusual with the optimization, and this really improved affinity as a result of that. And the bit here that's important to notice, there's no legal agreement in place when this work is carried out. And you can probably, some of you might see where I'm heading with this. The question is then, who owns the invention? John is employed by the company. That's fairly straightforward. He's an employee, so the company owns the rights to the invention through his work. But Maria is employed by the university, and she has obviously done some very important work there that leads to this improved affinity, which forms part of the claims that we're going to file in a patent application. So the university owns her rights to the invention. And both the company and the university own rights to the invention. So we could file with those two applicants, or we put an agreement in place so that the university assigns their rights to the company, and then we can file in the name of the company. So this is still quite a simplistic example. I am fully aware that there are some really complex collaborations, etc., that I'm sure a lot of you are doing. But really the take-home message is, please put an agreement in place that determines ownership in advance of the work being carried out. When you come to a due diligence exercise and this is scrutinized by the other side, and it suddenly comes to light that an application that was filed some years back actually should have been filed in the name of more than one entity. This is really a setback in the due diligence, and it can get quite difficult at that point. And just from a pure patent perspective, it's also a pitfall, because there are certain situations, without going into too much detail, where errors in the chain of entitlement, so from the inventor to the applicant, may result in the loss of the patent. And there is an example, a fairly recent example, where the Broad Institute lost a patent at the EPO to CRISPR technology because there was a problem with the chain of entitlement. So this is the sort of area that fills a lot of patent attorneys with dread, frankly, when there's something that comes to light where the chain of entitlement's been broken and the applicants were not correctly listed, and there's issues with priority and entitlement to priority. So we really got to be very, very careful about this. We got to make sure that there's an agreement in place that determines ownership in advance of the work being carried out, because in all the due diligence exercises that I have ever been part of, these are the questions that are asked by the other side. Who owns the invention? Who are these inventors? Were they employed by the company? Were they not? Well, how come that the company has the rights to the invention? Where's the transfer of the rights?
It can mold you into a Delta pilot, which isn't a bad thing.
So that's really important. So this concludes my section on ownership. So we have looked at the IP strategy and the IP portfolio and the questions that come up. And now we've looked at ownership and the questions that come up on ownership. Appreciate it's all a very sort of quick run through the main questions here. A lot to take in, but are there any questions at this stage?
Just to let you know, there's nothing in the chat box.
Okay, brilliant. So we're going to move on to freedom to operate strategies. FTO, freedom to operate, that's the third set of questions that will be asked by the other side in a typical due diligence exercise. And again, I can only emphasize this is, to me, it often is the question of, you know, has the company done their homework? When I as a patent attorney advise a client on due diligence, say a client that is carrying out due diligence on the other side. So I really want to see, well, what kind of analysis has this company done? Have they looked at IP in this area held by other entities? Have they done their research? How have they done it? What kind of searches have they done? How have they done their analysis? What kind of work have they actually carried out? I want to really see that they've done their homework. So why is the FTO needed? Well, obviously, we're talking here about due diligence, IP due diligence that investors may carry out, acquirers may carry out, licensees may carry out. But it's not just that, it's important to any company to secure market access, possibly produce an income via royalty streams, or of course, avoid legal disputes, because you do not want to get into any infringement disputes. What is FTO? It is an analysis of whether the company's commercial product or method, or the methods used in developing the product, infringe a third-party patent. And what is typically done, it's a search and assessment of third-party rights. And some technologies, as you know, can be very competitive indeed. And the space that needs to be searched is really quite large. And we see that in the space of antibody technologies. This should say IO targets. So immuno-oncology targets are very popular. There's a lot out there in the public domain when it comes to patents and patent applications. We also see it in other technologies, for example, vectors for gene therapy. So very competitive spaces. So how do you go about establishing freedom to operate in competitive spaces such as the ones mentioned? And also importantly, when do you do this exercise? And I think it's important that the exercise is carried out at the earliest possible stage, because this gives you a clear position for investment purposes. So in other words, as I said, these exercises are often extremely time critical. And once you kick off this process, you do not want to be starting an FTO search and analysis, because that does take time. You want to be on top of things. You want to be able to answer the questions to the other side. You do need to bear in mind that FTO is actually an ongoing exercise, and I'll come back to this, but you do need to review the freedom to operate as new patent applications publish, but also as the product develops, because as we all know, products may change upon further development. So how to search, and I think this is something that perhaps some of the, when you set out with this exercise internally in-house and you do not have a patent counsel in-house, this is sometimes a very daunting task, and it's quite difficult to understand what the best way forward is. Now, there's quite a lot of parameters that you need to decide on for an effective search. So are you looking at patents only? So granted patents can be a very effective strategy for some technical areas to limit any analysis, first and foremost, on granted patents to get a better idea of the space. Or are you going to include pending applications already? Pending claims may change during prosecution. Most likely they will change during prosecution. Are you going to get bogged down with that analysis, or are you going to focus on patents to start with? Secondly, which jurisdictions are you going to look at? Are you focusing on Europe and the US, or are you particularly interested in other markets such as China, perhaps Japan? Where are you going to manufacture your product, for example? That's a question that could be important for that jurisdiction determination. And then how do you do the search? Are you going to search by keywords, by patent classifications, look at specific inventors or other competitor companies? What kind of date limitations are you going to apply? So you can already see that this is quite a complex area, FTO, and I think any freedom to operate report is only as good as the parameters that you actually applied at the onset. If you do not get your parameters right, then you may not get the best out of this FTO search exercise. It's really important to carefully consider what kind of parameters you use, what kind of boundaries you apply. And sometimes a combination of different strategies is actually the most pragmatic approach. The question often arises, how do I search, and can I do as an in-house scientist or a person who is in the management of a company, can I do some searching, or do I have to give this to a patent attorney and then it's going to incur potentially significant costs? There is some searching that can be done on databases that are publicly available, and I have put 3 here for you on the slide. Some basic searching is fairly straightforward on these databases. For example, if you know of specific entities that are active in the field, you can easily carry out a search for entities using public databases. You can review the cases. Perhaps this already gives you a good idea of the field. When you come to more complex searching, then the public databases that are available are probably not the best databases to use, because they don't really allow you to have complicated and multiple parameters for your search strategy. And then it is much better to use commercial databases which allow you to conduct more complex search strategies. So it depends a little bit on what kind of searching you want to do, whether you can actually do some in-house or you have to ask a specialist to do that. Now, when it comes to the analysis, I think there's a lot of work that can be done in-house that you can already do, especially when you look at certain entities, and then you can look at the claims of granted patents. Now you need to, of course, firstly identify from the database which are the granted patents, which are the pending applications, so that you are sure whether the claim set you're looking at is actually pending or granted. But there's a lot that can be done in-house before you outsource this. When you come to pending applications, as I said before, pending claims change during prosecution, and I think it's quite important to be mindful of that and to understand that the claims that you get, for example, on Espasnet, a database that's maintained by the EPO and is widely used, and then you have the claims that were published. You don't have the claims that are still pending 5 years down the line. Most likely they have changed during the course of prosecution. So you need to actually consult the local register to understand the scope of the pending claims, and the scope may be narrow, so this case may no longer be relevant. Sometimes families can be quite complex, and you need to understand if there are other family members, divisional applications or continuation applications. And the expiry date is typically 20 years from the filing date, but this can be a bit more complex depending on whether a patent term extension has been granted or an SPC has been awarded. So really, when you look at very large portfolios, you have multiple cases in multiple jurisdictions potentially with different scope of protection. They all coexist and can be a little bit of a thicket sometimes to penetrate. I think in those instances, it's much better to obtain external advice to help you through this perhaps maze of cases with different claim scope in different territories. As I said before, FTO is actually an ongoing analysis, so you have to update this regularly. A patent application publishes 18 months after filing. So in many cases, you need to keep an eye on the space to see if there's new publications that could potentially be relevant and that you need to analyze. As I said, for pending applications, it's also worthwhile monitoring the progress of those. If you have identified applications that could be an issue, you want to see if they are actually going to be narrowed. So is the scope of the claims changing during prosecution? Perhaps the claims are narrowed and they no longer present a potential issue. Some cases, an applicant may not pursue an application and it will simply become abandoned. An application may be assigned to another entity, and that could also be useful information for you, especially if you're thinking about obtaining a license. And an applicant may file a divisional application or a continuation application in the US. So monitoring pending applications that you've become aware of is very important. And in a due diligence exercise, this is what the other side will ask. Are there any cases that you are monitoring? Are there any pending applications you are aware of that you are keeping an eye on? This comes up frequently. So granted patents, some patents do not get renewed for whatever reason, so also worthwhile having an eye on that. But what do you do if the path is not clear after your FTO exercise? That's obviously an important consideration. And what should your position be in discussion with investors if the path is not clear? There are exemptions from infringement in the pharmaceutical sector. They are different in various jurisdictions, but I just wanted to mention that there are exemptions that exist. This may be a possible discussion point, and obviously you need to get advice on that, but sometimes the situation is such that there's an exemption. You may want to consider workarounds the problematic IP. You can consider in-licensing the patent. Also, you can think about validity of the problematic patent or patents, and is that patent actually valid, or is there a way of attacking it? If it's weak, there's an opposition procedure in Europe where you can file an opposition within 9 months from grant of the patent, and you might decide to take action against the patent. And finally, if none of that works, the ultimate course of action could be to reconsider the R&D project. Of course, I appreciate that this is commercially oftentimes not viable and really a matter of last resort. So one would hope that either you don't identify anything problematic, or if you do, that you can work with these headings here and find a way around it. So in terms of practical tips, as I've emphasized before, I think investors want to see that you've done your homework if you're a company undergoing due diligence. This is really what it's about. Start everything, including the FTO analysis, as early as possible, so that when the due diligence project kicks off, that you're on top of things. Things move very fast in these projects. And the IP searches in FTO, in an FTO analysis alone can take a few weeks if it's a complicated space. It can take 2 to 3 weeks just to do the searches. And then if you have 400 citations, then that takes quite a long time to analyze as well. And that may well be outside the time frame of your due diligence project. So you need to allow time for this. And also bear in mind that the FTO analysis is always just a snapshot in time. And as I said, it's an ongoing project that includes monitoring potentially troublesome cases and also updating the searches, because new applications will publish applications published 18 months after the filing date. So that's important to bear in mind as well. And really, this brings me to the end of my talk. I've put down some resources here for you, which we have on our website, Yardley Screenshoot's website, with a few seminars here on various legal points, such as inventorship and ownership, covering this in much more detail than I have just done. And also validity searches, again, in much more detail than I've just done. And I talked about freedom to operate. This concerns validity of patents, but there's some overlap. We also have a dedicated resource for universities and spin-outs on this page. And this just leaves me to say thanks to everyone for listening. And if you have any questions, I will stop sharing now. Hopefully I'll be able to see those questions. Thank you very much.
Thank you, Barbara. There are a couple actually in the chat box.
Yeah, I'm just looking at the last question. Is it possible to mitigate any possible FTO issues by saying that the offending claims are unenforceable or unlikely to be enforced? So in my slide, I mentioned that if the path is not clear, what do? You conduct a validity analysis. So maybe it is possible to argue that the claims are not valid. So indeed, yes, the answer is yes to this question. It is in theory possible to mitigate, but of course, that is on the assumption that you have done that analysis. So obviously, if you argue that something is not enforceable, you need to be able to support those arguments. If you argue that with the other side, they will say, okay, this sounds great. What are your reasons for thinking that this patent is unenforceable? And then you will most likely need a formal opinion from a patent attorney in the relevant jurisdiction, which backs up your comments. How does Brexit affect all of this? This, yes and no is the answer. I don't think Brexit as such affects how this due diligence exercise is run at all. You know, Brexit does not affect the questions that I explained to you are often being asked by the other side, not at all. At the moment, I don't think that Brexit will affect any of this. In the future, it may do, because there is a change in the court system across Europe. There will be a centralized court rather than national courts as we have now, and there will be new case law coming out of the centralized court. So this may change sort of interpretation of infringement and validity, but this is quite a long way down the line. And certainly Brexit doesn't affect generally what questions are being asked. So those would be the answers to the two questions that have been raised so far. If there's any other questions, please feel free to ask now, or if you want to ping me an email later on, I'm very happy to answer any questions that you may not wish to ask in this more public forum with the presentation being recorded, etc. But if there's anything else that you'd like to know, I'm very happy to address any questions in a follow-up email.
Thank you very much indeed for your time on the session, Barbara. That was really insightful, really interesting overview of the value that IP can have when you're talking to investors and the sorts of questions that they're likely to throw in the direction of young companies, startups. So really useful. Yes, the session has been recorded. And if you do want to follow up with Barbara, you can do so via the conference app. So please utilize that as a means to do any follow-ups should some comments or questions come to you post-session. And I do hope everyone has enjoyed and found this insightful. So if there is no further questions, you've done a sterling job, obviously, Barbara. There's no additional questions there.
Yes, I left quite a bit of time for questions, but
we do have a hand up from
okay,
Nicola.
brilliant.
Did you want to unmute to ask your question? Or was that an accident hand? Oh, maybe it was just a clap. Sorry, maybe I misinterpreted that. I'm sorry. I beg your pardon. Sorry. Okay, I can't see any further ones there. So we will be returning tomorrow at 10 a.m. with the innovation workshops on a session on listing in Asia in association with Mills and Reeve. And there is other on-demand content that can be accessed in the meantime. So with that, I will bring the session to a close here and just wish everyone a good rest of the day and say thank you for joining. Do take care. Thank you.
Thank you.